I was just talking, I think it was last night or the night before, with some visitors from Israel. And they were telling me about how in Israel, because of the discrepancy between the religious courts and the civil courts, there's often a race to the courthouse when a marriage isn't working, where if the woman doesn't file first in the civil court, it's going to get filed in the religious court, and the religious courts, out of tradition, are very sexist, are going to protect the man at the expense of the woman. And so there's a bit of a jockeying for position. And I thought to myself, wow, that's a good illustration of therapeutic jurisprudence. The fact that that creates a jockeying for position, a race to the courthouse, that's precisely at the point when the marriage isn't working, where they need to talk with one another, where they need to see if they can get some marital counseling, where they want to see if alternative dispute resolution mechanisms can allow them to repair their marriage and move forward. Instead, the law there pushes them to run to the courthouse and file first and get on the bandwagon. And of course, once you file a divorce action, you're making all these allegations about the other spouse, and they get upset about it, and you're setting in motion all those forces that are going to lead only in one direction, a nasty, bitter divorce that's bad for the kids. So maybe that's a good example. Actually, maybe the whole way we in America deal with divorce is a good example. We have contested matrimonial matters in which, when people are getting divorced, we go and have a trial, and it's all about jockeying for position. And of course, litigation brings out the worst in people. It brings out guile and deceit and lying and accusations, and what happens is it's World War III, and that husband and wife are going to hate each other. We're going to create wounds that will never heal. And if they're parents of young children, who's going to suffer? The children are going to suffer. Those folks might not be married any longer, but they're going to have to relate to one another over the rest of their lives as co-parents. There's going to be plenty of occasions where they're going to need to put their own individual, personal interests aside in order to further the children's interests. And that always means talking with the spouse on the other side and trying to resolve things in ways that are good for the kids, even if you're going to be divorced. Well, divorce litigation prevents that from happening. So we need to use alternative dispute resolution mechanisms, mediation, negotiation, and settlement, and of course, collaborative divorce. Collaborative law is what I think of as another very good example of a therapeutic jurisprudence solution to this problem. We didn't start collaborative divorce, but about 10 years ago, I had a call from Pauline Tesler in California inviting me and a few other people to come out to California to meet with her for 2 days in her law office and to sort of plan how this model of collaborative divorce could be expanded. It was, of course, a wonderful idea that Stu Webb, and I hope you've interviewed him as well, had. Enough is enough, too much litigation, we're harming our clients, let's see if there's another way. And Pauline, I think, moved that in a new direction with a lot of interdisciplinary cooperation and developed the idea of, the four-way agreement and the agreement not to litigate and all of that. There's a tremendous incentive that lawyers have, unfortunately, to push these matters into litigation. The client goes to mediation, and they bring the settlement back to the lawyer, and the lawyer looks at it and says, "Nah, I could do better in court. Forget it. Don't do that." And to the extent that the lawyer is doing that because of the lawyer's own selfish pecuniary interest in getting a larger fee, that's unethical. The lawyer is a fiduciary. The lawyer owes a duty to the client to act in the client's best interest, and it's almost never in the client's best interest to have that third world war of litigation. Sometimes it's necessary, but usually it's not. The lawyer should try to keep the client away from that. And here, what we often see is that mediation doesn't work in this area because the lawyers tout the clients off it and get them into litigation and fan the flames. and then they're off and running, and it's just an outlet for their unresolved anger. It's a stupid thing, and it's terribly anti-therapeutic. So collaborative divorce is a wonderful model. It takes away the financial incentive that the lawyer has to go to court, because the lawyer is being hired as a settlement lawyer. The lawyer's job is to settle the case. If the lawyer can't settle the case, then the lawyer has to step away, and the clients have to get other lawyers if they're going to litigate it. And of course, there's going to be cases where they won't settle, but most often, if both parties come to the table in good faith and say, gee, we want to resolve these issues in a fair way, in a way that will help our children to survive and prosper, most often they're going to be able to reach agreement through the auspices of those lawyers. And that insight that the lawyer's role is to settle the case, winning is settling, losing is if they can't settle and have to go to court. And that unleashes in the lawyers all that wonderful creative energy, creativity that we lawyers have. You know, there's going to be some roadblocks, some obstacles that are thrown up. Well, let's see if we can structure it this way or that way and get around that problem, accommodate that issue, and nonetheless get this back on track and resolve it. It is a wonderful example of how we can change legal arrangements in order to avoid the obvious anti-therapeutic effects of divorce litigation, in order to foment settlements that will allow the parties in a much more psychologically healthy way to relate to one another after their divorce. They're not going to be intimate partners any longer, but they're going to be partners about certain things, particularly if they have children. They're going to go to, weddings and funerals. They're still in the same family. Rather than hating one another, they're going to be friends, hopefully. And I think collaborative divorce as a legal process allows us to reach that objective in ways that certainly divorce litigation makes it almost impossible or very difficult to do. So I do see that as a good example of therapeutic jurisprudence in action. Everyone loves and cherishes Steve Kiva. He's done a wonderful job during the years when he was an editor of the ABA Journal. I think he got many of us to write articles and to be the subjects of articles that really pushed Steve's vision of new lawyering, of how to transform law. Of course, that's the title of his book, Transforming Practices. And he was talking about the sort of felt need that many in the profession experienced about the unsatisfactory nature of law practice, and people striving for new ways, for different ways to practice that were more satisfying, more professionally and personally satisfying, more in line with their spirituality. And I think his book was itself transformative. And so I knew Steve in those years. I'm proud to say that I wrote a book jacket blurb for Steve's book, Transforming Practices. I haven't read that blurb in many years, but I think I called it, a good example of therapeutic jurisprudence in action. And I think Steve made an enormous contribution during his years with the ABA Journal and as an author of that very important book that has really paved the way for the transformation of our profession. We all owe a tremendous debt of gratitude to Steve for that, for helping to point us in the right direction.